Great. Assalamu alaikum, everybody. Welcome to this webinar on Oman's PDPL. I'm very, very pleased to welcome you. I think a lot more people are going to watch this on the YouTube channel because it's the middle of the day and it's not convenient for everyone to attend. We certainly please do put any questions you have into the chat, and we will leave quite time for questions at the end, of which I think I will have many. Let me just kick off by introducing this webinar, and then I'm going to introduce Shah and ask him to speak on the more technical end of this law. So a very quick introduction to the speakers. So our first speaker will be Shah Alam, and as you can see, he has lots of IAP accreditations. He's a DPO in 11 countries and the founder of the PDPO Club Oman. My name is Bilal Ghafoor. I have pretty much the same accreditations. I'm the managing director of GCC Data Protection. I've been doing this for about 15 years, and the last 3 years within the GCC region. So Shai and I have both been looking at this stuff, and I have to kind of tell you that the reason I got to know Shah is because about 2 months ago, I was so puzzled by the Omani PDPL. I thought, no, I don't understand this. This doesn't make sense to me. And I had to find somebody to reach out to, and I reached out to Shah, and he not only called me immediately to help me understand the things I did not understand, but that's actually then I thought, well, maybe I'm not the only one. Maybe there are other people and they want to understand the same problem around permits. And that's one of the reasons why I asked Shah to join me at this webinar so that we can unravel some of these problems. So we are going to talk initially about the MTCIT permits and the exclusions, which is the bit of the Omani PDPL, which is more difficult to understand. And then I will cover some general points about compliance with the PDPL. But what I'm going to do is I'm going to ask Shah to kick off and speak. Then I will speak, and then hopefully we will have time for questions at the end. So Shah, could you share your presentation, please?
Yeah. So is it available? I mean, is it
Yes.
visible
Yeah.
for everyone?
Yes.
Okay,
Yeah.
perfect.
It is.
Okay. Thank you so much, Bilal, for your introduction. Indeed, it was very short but fruitful discussion when you called me. And why I help you immediately, because I have been in Oman since last year, and I was going through a lot of these questions mark, and it was difficult and hard for me to find the question. So I have spent good time in order to understand the requirement, and considering that I'm trying to help people who are not in Oman or outside of Oman, and they are having such questions so that they can able to understand a right way. And considering that, I would like to start with giving the basic about this law. So Oman, they come up with their own law in the form of royal decree in 2022, and it took 2 years to come up with the executive regulation, which came in 2024 Feb. And they have given two extension. Initially, the extension was to comply with the regulatory requirement by mid of Feb 2025. Then people were not ready. They have given one more year extension. So from Feb 2026, it is in force, and all the companies which are based in Oman, they need to comply with the PDPL requirement. Whoever is collecting personal data related to Omani national, Omani resident, or visitor who visit Oman. So there are bit not clarity in the law itself. So what I have done, I just picked up the law so that I can give you high level information. So first, let me give the brief about MTCIT. So it is the regulatory requirement like we have in Saudi Arabia, SADAYA. SADAYA is the regulatory requirement who look after PDPL as of now. And European region, we have another. Likewise, MTCIT is the regulatory body who look after the PDPL compliance. They are the one who issue a permit. So in Oman, as part of the regulatory requirement, if any organization who are going to use personal data, part of their business processes, they need to request for the permit, and the permit is valid for 5 years. And if there is any change in the business processes which we have submitted during the permit, we need to go again for the reapproval. And as of now, there are some exception has been given, which I will discuss in the next slide. In addition, what MTCIT do, they look after the regulatory oversight. So part of the regulatory requirement, they will be conducting audit. If there's any violation, they will do investigation, and they will involve other regulatory, which is more related to incident management, which is CDC, and they are the one on issuing the executive regulations. So based on the feedback which they got, the on the current regulatory requirement, they are working on it, and they will be come up with some amendment within coming 3 and 6 months. And if someone is using cloud services which is not based in Oman, because Oman we have limited cloud service, and there are so many application or technology which is on cloud. So company, they don't have options, so they are in order to avail the services, they need to move those personal as well as sensitive data outside of Oman. So as per the law requirement, Article 6, where any company who is holding sensitive data, and if it's going to be outside of the Oman, they need to take approval from the regulator. As well as we have something called CDC. They are the uh, security ministry. They look after security control. So we need to have approval from them before taking any services which is hosted outside of the Oman. And of course, if any violation, if anyone is not respecting data subject right, they are the one where we go as a data subject, raise our query, and they are the one who take action and give penalty. And the penalties start from 2,000 up to 500,000 Omani riyal. And if anyone within Oman or outside the Oman, they would like to reach out to PDPL regulator, they are available on pdpc@mtcit.gov.on. So any company who is based is Oman, and the PDPL is compliant. If they have any question, they can directly reach them out. If some data processor who is processing data on behalf of controller and they are outside of Oman, if they have their own query, they can also reach out to them directly. And MTCIT, they have done very good job. If you see the URL, you will find the MTCIT web URL and the sector, and they have the one web page designed for personal data, where they have designed the template, and they have given the guidelines form. So any company who are small in size, they can't afford SME, they can go through those available policy guidelines and form, and they can prepare themselves in order to meet the PDPL compliance requirement. So yeah, in order to authorize ourselves or as a company, there are certain requirements which we need to fill, and there are one form which is available on the MTCIT website, which I have given you earlier. So you need to go there, you need to download the form, and you need to fill few information, which is the information of your DPO, the information of, I mean, the purposes. In short, you need to have your DPO detail, including the ROPA, and you need to give them some uh, comfort. The technology being used by the organization, it has a proper security control in place. So if we are using some services which is outside of Oman, and we rely on some third-party companies or cloud service provider, we need to have some kind of uh, assurance from them. It can be internal audit report, if they are ISO 27001 certified. Those information we need to incorporate with those authorization form and submit to the regulator. They take their time, 2 weeks to 1 month, and they will come up if they have any further concern in order to have more information, or they give approval directly. Okay, so this is the template uh, where we need to fill up the information. I have just taken it and design on the PDF so that it is easy for people to go through it. As of now, they have given some exception where this personal data processing permit is exempted. In that, there's a one special, I would say, area where people are taking the advantage, because as of now they have mentioned if there is a contract between data subject and the party, you don't need to take permit. But they are working on it, because I have a discussion with them. They're working on it and they are coming up with the revised executive regulation. But so far, the misunderstanding which people have, that if they are exempted, they don't need to comply with the regulatory requirement. Okay. Yeah, this is the Article 3 where most of people are having a doubt. So these are the entity exempted from data processing. In that, if you see national security, which is everywhere around the PDPL regulatory requirement, which cover national security, state administration, legal, economic, vital, and in that, if you see G, the contract execution, this is where most of the organization get confused. They think or assume since we are exempted, we don't need to do anything. That's wrong approach. So we have a law, we have 45 article in that law which we need to comply with it. Okay, there are some exception, as I say, for the permit, but it is more related to permit. Even for that exception, we need to comply with the requirement. We need to have policy, ROPA, breach management, all this requirement in place, and we submit this requirement to the regulator MTCIT to take their exception. We should not assume by default that we are exempted. We need to consult with them. So yeah, the key takeaway from this, I mean, there are 10 cases exempted, but organizers must still comply with all the requirements. This is what I say. I mean, by going those requirements, we should not just think by ourselves that we are exempted. We don't need to comply with the requirement. They need to discuss, they need to ask or contact MTCIT or regulator before taking such a step, because you cannot process personal data, sensitive data without meeting the compliance requirement. Exception means should not be, there's no obligation. There are certain requirement, as I said earlier, you need to have in place and you cannot ignore it. So this is something related to my slide, Bilal, but there are certain questions. Let me just okay, there are certain question I picked up because these are the my question which I was looking the answer. I thought to capture all together and share with the team. So one is the common question that exception means we are exception to comply with the MTCIT regulatory requirement, which is not the right way. Exception means only you are getting exception for the permit, but rest of the regulatory requirement we need to comply with it. And another one I remember, if an Omani business receive a data subject right request for data covered by exception, do they need to comply? Yes, the organization must comply with the right request, regardless of whether the data falls under an exception or the exception do not override individual rights. That's always at upper hand. And again, one of the question I remember, the people they are, since they are exempted, do they need to prepare the ROPA? Definitely, they need to have ROPA in place. They need to have the privacy notice in place. They need to have a privacy policy for their organization. So all the things they need to comply. They should not think, again, I'm saying the same word, that they should not think that we are exempted for permit, so we don't need to comply with the PDPL requirement. Still, they need to comply with all the article, but for permit, definitely they need to consult with the regulator. They need to write an email and wait for their email. Once they say you are exempted, and they give the timeline, you are exempted for 1 year, you are exempted for 3 year for the permit, and they're working on it. Since it's a new law, we are in the initial stage. It takes some time to reach the maturity. So regulator are flexible, they are very supportive. If someone has any query, they just need to write to them, and they act, they respond on timely. So this is what from my side, Bilal. I hope
Yeah,
I
no,
finished in your
I'm take
time.
over. I think so. I mean, this might be actually a very, because this is so confusing, although you've brought great clarity to it. This might be a good time for us to, for me to like maybe ask you a couple of questions. So the
Yeah,
way in which, the reason I called you initially is because the way when you read the Omani PDPL, it literally looks like all that most sensitive stuff. So we're talking about your health records in a hospital. We're talking about like any criminal acts. We're talking about your biometric data. We're talking about all the things that people would naturally say, oh, that needs more protection. The law as it is reads like, oh, you don't have to protect any of that because that's not subject to the law. And it's only the uninteresting data, like just straightforward personal data that's not sensitive, falls within the law. So it seems to me like it's been just badly written. I think your interpretation that actually what they're probably trying to say is that if you're just processing normal personal data and that's it, which is very, very rare, I don't think anyone does that, because the moment you have an employee and your employee, you have like sick leave for an employee, or when you're employing somebody and you have to ask them as part of a background check, do you have a criminal record? Then you're immediately processing sensitive personal data. Now, I think what they were trying to do is to say, if you are processing more processing sensitive personal data, then you also need to register with us. All right. I think that was probably the intention, and they've made a mess out of it. It's very, very difficult now to understand. That's why I called you in a panic, thinking, no, 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 I must be crazy, because it sounds like they don't want my health records to be protected, but they do. But the law only applies to a marketing email trying to sell me, a new water bottle. That's what they want to protect. They're not interested in my health record. But what you're saying is actually don't read it like that, and you're saying that the MTCIT has talked about changing things, and they're
right.
talking about the idea that they're going to clarify it, and that you actually have to comply with all of it all the way through, all right, and that you should not count yourself as being exempt unless and just from the permit. You can never be exempt from the law. You might be exempt from the permit, but you should email them, and you've already said they're very, very friendly people. They might take a while to get back to you, but they'll get back to you and say, no, 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 you're not exempt. You have to come, you have to register for a permit, or they'll say you're exempt for a year or 3 years or whatever period. But that's what your advice is. But generally,
Yeah,
it is to ignore any idea that you don't have to apply to law to over all of your processing, because you absolutely have to.
yeah,
Is that a fair summary of what you've been saying?
yeah, yeah, right.
Yeah. Okay. So I think that's been really, really valid. That's where I was very, very stuck, because the law, it's not straightforward to understand, because I think at the heart of it there's a mistake, or there is something very, very kind of strange happening. But I think Shah's advice, and this is the advice that I was giving to all of my clients, was this doesn't make any sense. It doesn't make any sense to say protect your marketing data where you're selling a water bottle, but if you have health data, the law doesn't apply. That cannot be true, and therefore protect all of it and make sure that you apply the PDPL to absolutely all of it. So yes, that's been really, really helpful. And again, of course, we will certainly take questions towards the end. I'm going to kind of run you through some of the features of compliance. Obviously, it is not possible to run through every single detail of an entire privacy law in 15, 20 minutes. But what I'm going to try and do is I'm going to try and pick out some of the more interesting things that need to be done and some of the challenges ahead of us. Can you all see my slides?
Yeah.
Yes, great. Okay, so very much as Shah has said, you have the PDPL law itself, and it has various different sections. And then supporting that, coming out a couple of years later, you have the executive regulations. And the executive regulations are a mixture of helping you operationalize and give detail on what the law says, and then it, in some cases, introduces completely new subjects. So we're going to try and kind of go through some of these. The most fundamental thing when you are, and this is true, I think, of almost every privacy law. So if you have 500 staff in your organization and you do not have a list of staff, their roles, their grades, who is their line manager, who are they paid, how much are they paid, you cannot manage your staff. If you have an organization that is giving out, 1,000 laptops to its staff and they don't have a list, you cannot manage your IT hardware. Personal data is no different. Almost every data protection regime demands that you have a register of personal data processing, which in other regimes is sometimes called a record of processing activities. It is a list of what you have, and it's often quite a long list. These are the elements that are prescribed in the list, and it pretty much covers things like, what is your personal data? Why do you have it? Where did you get it from? Who do you share it with? Are you sending it overseas at all? How are you looking after it, keeping it safe? Are there any breaches around it? So it's by formulating this kind of list into a register that for the first time ever, you can keep control over your data. And this is exactly what the Omani PDPL tells you you must do. So repeatedly, there's this really interesting phrase that keeps on coming up within the PDPL, which is unusual. I've not really seen it in very many other pieces of law. It keeps on talking about having controls over data. And the kind of definitions are given here. And the first one is all about risk to individuals. What is the risk going to be to your data subject? What is the risk going to be? What are your procedures and controls around transporting and transferring data? What are the technical and procedural measures? So technical is something around maybe the IT and the systems you're using, and procedural talks a little bit about what is the guidance, how are you telling people to do things. It's more around the people training, because data protection is neither about computers, nor is it just about people. It's about the entire environment where data is processed, and then any other controls or procedures determined by the regulation. So you have to take a very, very holistic approach to how you are going to look at and manage your data and make sure you have control over it. Now, very famously, the Omani PDPL has consent at the heart of it. Most data protection regimes do not do this. They recognize that consent is only one of 6, 10, 20, 50 lawful bases for processing data, whereas the Omani PDPL is very, very heavily into consent. And what does consent look like? Well, what the regulations tell you is that consent has to involve transparency and honesty and respect for human dignity. And this is very, very nice. This is something where it reminds us that when we are asking someone's permission, when we are asking for their agreement, that we have to be clear. What are you agreeing with? You have to be honest, that you cannot hide things, and that you have to respect their dignity as a human being. So when someone consents, it has to be clear, It has to be explicit and understandable, and you have to prove that consent in a written manner. Now, this is quite difficult. Quite a lot of the time, consent is given verbally to lots and lots of things, and maybe says that you can then keep a written record of that, but either way, ultimately, you have to have a record in writing to show that consent was given. But it's very, very nice how it reminds us that it's about human dignity. There is a lot here about children's data, and children's data here is a shorthand for people who do not have capacity. So if you are processing children's data, obviously a child cannot consent. And so you must get consent from a child's guardian. And this also applies for those that lack capacity. So we're thinking here of perhaps older people with dementia. We're thinking of any other vulnerable person. You know, they don't necessarily have to be old. They may have severe learning disabilities, etc. If they are not able to consent and not able to make those decisions, you need to find a guardian for them. But whatever you do, again, it reminds us that you have to be very clear about why you're processing the data, free of deception or manipulation. Now, some of you will be familiar with the idea of something called dark patterns across the internet, where people are trying to get to sign you up to a service of some kind, but they don't really make the terms and conditions very clear. In fact, about 2 weeks ago, my wife was horrified. She had $40 debited from her account, and she was really angry, couldn't work out where it had gone. Eventually, we Googled it and figured out that it was she had converted a PDF into Word, but what she had done, she had understood that if she gave her credit card details, she would have to then activate her subscription. But in very, very small details, it said, if you do not log back in, then we will assume that your subscription has automatically been activated. So this is a dark pattern that is deceptive. They hid the essential terms and conditions in a very, very small place on the website. The Omani PDPL is very, very clear. You cannot do that kind of trickery. In common with most data protection laws around the world, it gives data subject rights. So we will recognize things like revoking consent, so being able to say, no, I no longer consent to this, to be able to correct personal data that's wrong, getting a copy, getting your personal data transferred from one data controller to another, erasure. So all of those we recognize, and the Omani PDPL is very generous to us. It gives us 45 days to comply with all of these. The last one is breach notification, where the deadline is much, much shorter. It is up to a maximum of 72 hours, but we'll talk about that in a moment. Now, if people are going to consent to something, there is no point for me asking for someone in consent in a different language or in a way in which they do not understand it. So privacy notices have to be clear. There cannot be any deception. So they have to be in writing. They have to tell you who is the data controller, who is the organization collecting the data, who is the data processor, where might their data end up going. They have to give details of the DPO, the purpose and the source, a description of the data they want. They have to explain to you what your rights are, and then anything else. And then in the anything else, it may well be, exactly as Shai said, quite a lot of data in Oman has to go cross-border because not all services are available in Oman. So if you're sending data across the border, how are you doing this? Why are you doing this? So all of that kind of detail needs to be in there so that somebody can be informed before they consent. You have to nominate a DPO. Now, a DPO is appointed by the controller to facilitate compliance with the law and its regulations. This is much, much more sensible than the Saudi PDPL. The Saudi PDPL actually makes the DPO responsible rather than the organization. But here, they're there to facilitate compliance. Their main duties include advising the controller. They are not the person responsible for data protection. If there is a breach, it is the organization that takes the fine. It is not the DPO. And they also act as a point of contact with the ministry regarding all matters related to data protection. Now, I'm not going to talk about security very much. The security provisions are pretty much the same as any other data protection law. They say they shall guarantee the confidentiality of personal data and non-publication unless there is consent. So security is everything, everything trivial, from how do people get into the office? Is there CCTV? Do we have a clear desk policy? Are we controlling our environment? Do we have access controls, logins? Are we looking after our network? How do we train our people to make sure that they're not being phished? All of those things are in here, but again, I'm not going to talk about security very much because security is its own subject area. Now, breaches are the thing that we are most worried about, I guess, because this is where most of the fining around the world takes place. So, as I said, you have 72 hours from when you first become aware. You must send a notification to MTCIT under certain circumstances. You must notify the data subjects under certain circumstances. You have to certainly have a process so that all of your breaches are documented. You need a process for people to be able to report breaches, to document them, to assess them, and then to be able to show how you reacted to all of them. And then the maximum fine is 20,000 Omani Riyal, which is quite a hefty fine for this. I think this is the maximum that is available under the law at the moment. If you are marketing to people, then you are subject to the PDPL. And again, consent is the big feature. You have to have written consent, and that is now not a surprise because we understand that consent is the key cornerstone. But it also talks about the means of marketing. So if you are phoning people up, if you are going to be emailing them, are you using cookies and trackers within your website? Are you using web beacons and pixels? Are you going to be sending them postal stuff? Whatever it is, you have to get consent, which also therefore means things like your cookie banners now really, really matter, because if that is what you are using to market, and a lot of people do, then you will need to understand how to get permission for all of that. And then you have to have very, very clear opt-out mechanisms and to be able to honor those opt-outs. If I opt out, you have to stop processing my data for marketing pretty quickly. Cross-border transfers, again, as Shah has already said, this is a big issue. You have to get consent. The only two ways in which to not get consent is if you have an international obligation. So this is a state-to-state obligation, which will not be about most organizations, or you anonymize the personal data. So it is no longer personal data. And obviously, if it is something is no longer personal data, then actually the data protection law doesn't apply to it. So the Cyber Defense Center, the CDC, which again Shah referred to, will have to give an approval if sensitive data is stored or processed outside of Oman. And this is again one of the clues that leads us back into the idea that you may be exempt from a certificate, the need to get a license, but it does not mean that if you're processing sensitive personal data, you don't have to worry about this law. You absolutely do. The Cyber Defense Center will need to approve if you are storing data outside Oman. And one of the most common ways in which this happens, which happens in almost every organization, HR software as a service. You have an HR database, it stores sickness and various medical conditions of staff. Usually software as a service, unless you manage to localize, will often be an American system. You need to ask the CDC for approval. You have to assess whether the receiving entity, not the receiving country, but the receiving entity has an adequate level of protection. Now, this is very, very interesting. This means that you may be able to outsource your work to a country with, for example, no data protection laws, for example, Pakistan or Bangladesh, because it's cheap, because it's efficient to do, but you must assess, does the organization have adequate levels of protection, which are usually around training staff, security, and that kind of thing. And maybe even insurance in case something goes wrong. And all of this requires you to do a risk assessment. If you are sending something out, you cannot just accept the risk and move on. You have to show your working and say, this is how I worked out what the risk might be. It repeatedly talks about controllers and processes, and here are just some basic notes on these. Controllers and processors actually have almost identical obligations. The main difference is that the entity that has direct relationship with the data subjects must take a lead on getting consent, privacy notices, etc. So if my organization is using Microsoft 365, Microsoft 365 is my data processor, and I, as the main company, must serve a privacy notice to say, hey, your data is going to go to Microsoft. We're using Microsoft 365. It's all in the cloud. And so I must do that. But if you are, if I outsource running a campaign to work out customer satisfaction rates, then it is the survey company that is usually going to go off and get in touch with data subjects, and maybe they will have to serve the privacy notice. Now, what it says here is very interesting. The processor acts as the agent of the controller regarding civil and administrative liability. So if you are a data controller, you get it wrong, you can absolutely be liable to penalties, etc. And obviously, if there are any criminal liabilities, then that is a separate matter that will also get dealt with. So the fact that you are a data processor doesn't take you off the hook. You are absolutely going to be liable, which means you have to be careful. It also means that the controller has to pick the right processor to make sure that their interests are well carried out. Time and time again, it talks about cooperation with the ministry. I have never seen a law that was so short that kept on talking about the ministry, particularly with cooperation about the ministry. All roads lead to the ministry. There is a power of audit, which I'll talk about. There is a mechanism for members of the public to complain. When you build your ROPA, it says your ROPA must therefore be available to the ministry. When there are breaches, the breaches under certain circumstances have to be reported to the ministry. So all of these things are places where you may well, separate from the license, have to interact with the ministry very, very closely. And then I think this is again, extremely unusual. I really like this. This is very, very rigorous. It demands that you make yourself subject to external export. All data controllers and data processors have to appoint an external auditor. The external auditor cannot just be anyone. You cannot appoint your friend. They have to be independent, and they have to be licensed by the ministry. And they will have 60 days to provide the audit report. So this is quite a rigorous idea. Usually what happens is that the regulators in other countries, so SADAIA in Saudi Arabia, the ICO in the UK, they will usually do whatever investigations they want to do themselves. This is very much like saying, no, we want you to have an external audit, a little bit maybe like ISO 27001. You pay for the independent audit. No, you can't pick anyone. We will decide who you can pick. You can pick from this pool of people, and there is a limited amount of time for them to provide an audit report. So this is a really, really interesting and quite unusual requirement for there to exist. So that is kind of the end of my very, very quick roundup of the PDPL law, and we are now happy to take any questions from you.
Before that, I just wanted to add two important things, Bilal, which I had a discussion with MTCIT, and they clarify. One is the DPO. So there are so many companies, they are small in size, they can't afford a full-time DPO. So initially, when we raised this concern to them, they say no, either the company has to nominate someone who's independent, or they can hire new resources. It was a challenge. So what they say in the recent, which will be coming up in their revised executive regulation, they say the company can outsource. So DPO can be outsourced services. Those company who are small in size and they can't afford full time, they can have someone as a DPO. In addition, the external audit, as you just mentioned, is it part of the executive regulation requirement? Then they need to appoint external auditor. It should be authorized by MTCIT. This is one of the other challenge. So I raise this point to them. They come back that the company can have any independent external audit entity. It's not that it should be authorized because we have very limited entity. But if there is any violation, in that case, they will force entities to go with the authorized audit firms. But initially, like if I need to do audit, I can hire any audit firm who are independent and they are well known in the market. So these are the 2 points I would like to add in this session because this is not available anywhere.
That's very, very useful. Yeah, because I'm aware that just yesterday you were meeting with the
Yeah,
regulator, so you have the most
yeah,
up-to-date information. So that's really interesting about the DPO because I am already the DPO for two companies in Oman, and I think one of them literally they're really small. I mean, they like I couldn't find anything in the regulations saying that it could not be somebody external. And so I just said, well, it doesn't say you can't do it, so you must be able to do it. And so one of them I literally do, I think I do 8 hours a month for one, and I think the other one is 12 hours. It's not very much. They're very, very, very small, and they just list me as their DPO, and that's it. And so they fulfill this requirement because they have some slightly difficult processing they do, and they wanted some decent advice on how to get it done. So I think that's something that people are doing, but it's very, very good that you've got them to clarify that it can be like that, because obviously Oman is a relatively small country, and so it must be impossible to find suitable DPOs, and it would just become really, really expensive. And you're quite right. So when it says everyone has to be, does this mean my local newspaper delivery people who just send newspapers to a few roads